to share his thoughts. Thank you.
Thank you very much. And Mr. Sham Diwan, chairing this very important panel discussion. Justice Mukta Gupta, Mr. Vikramjit, Mr. Acharya, Mr. Srinivas, and other distinguished members of the legal fraternity who are available on this Sunday morning here. I'm grateful to the organizers for providing me with this great opportunity to give some insight that I have as far as this new law that would be unfolding from 1st of July 2024, Bharatiya Nagarik Suraksha Sanhita is concerned. Because most of the important and controversial issues have already been addressed by other panelists. So I'll be touching on certain issues that are left untouched. Let me start with this information that these laws are not what the committee that was meant to draft these laws had proposed. The last 2 days of discussions amongst the committee members were held at Dr. Ram Manohar Lohia National University, where I come from, and I was fortunate to coordinate those discussions. So I know that what was proposed and what we have that would be implemented from July 1, 2024. The drafts that were submitted certainly did not change the structure. Often we do not attach much importance to the figures and numbers in the legislations, but then these legislations, the IPC, the CRPC, the Indian Evidence Act, they have been with us for the past 150, 160 years. And we are so familiar with the certain numbers that immediately once we hear those numbers, we visualize that what kind of provision we are talking about. Same as with the CRPC as well. Mr. Acharya very rightly pointed out that without changing the sequence, without changing the number, whatever modifications were required, whatever changes were required, could have been very easily inserted into that scheme. Now the issue is that CRPC, or for that matter the Bharatiya Nagarik Suraksha Sanhita, the BNSS, is as much of a concern for lawyers, judges, as it is for the police officers, and that too for the SHOs and even the lower rung police officers. They are so well versed, they are so conversant with these numbers. You just say 161, you just say 154, you just say 164, 40, and they know that what provision of CRPC they are supposed to look into. Now it's very difficult because they would be also dealing with the pending cases that would be dealt in accordance with the existing CRPC, and from July 1, 2024 they would be referring to the new provisions. Most of the new provisions are in the form of clauses. There are no independent provisions in all. So that's going to lead to utter chaos. This is what I visualize, and this is my gut feeling. Now, everyone spoke on the title of that and the need to have this in Hindi. Now, I have something more to add to that. Now, this criminal procedure that we have with the title BNSS uses the word Bharatiya Nagarik Suraksha Sanhita. Nagarik, when translated into English, means a citizen. Now, this procedural law is as much for the protection of a non-citizen as it is for the protection of a citizen. We know that even alien enemies, even those who attacked the parliament, even those who were involved in other terrorist activities, non-citizens, they were also accorded fair trial as per the provisions of CRPC. That fairness is due to everyone who is accused of an offence under the Bharatiya Nyaya Sanhita, of course, but that title is something that they could have a better word for. Now, everyone spoke on this EFIR thing. In fact, I was fortunate to be part of one consultation that the Law Commission of India had organized recently. And pursuant to that, Law Commission of India had submitted its recommendation number 284, if I may recall correctly, on EFIR. The provision as far as EFIR is concerned, that's certainly a welcome provision. But then there's nothing to prevent the misuse of it. As Mr. Acharya very rightly pointed out that there have been instances when people would be filing frivolous complaints, but those frivolous complaints would be leading to a lot of problem and all for those against whom those complaints are made. Now, this provision of EFIR that would be opening floodgates of such frivolous complaints, and there is nothing in CRPC, that there is nothing in the Bharatiya Nagarik Suraksha Sanhita that would be in a position to keep a check on that. Another anomaly that I find as far as EFIR is concerned is that the person making that complaint has to sign it within 3 days, only then it would be taken on record. But we all know that the moment police receives an information, that has to be taken on record. Now, that could be related to a cognizable offence. If it relates to cognizable offence, it must be recorded as an FIR. If it relates to a non-cognizable offence, even then it has to be taken on record. We know that police keeps two kind of diaries, one that we call the daily diary. That daily diary must contain every information that police receives from whatever means. So this is a little anomalous that it would be taken on record. Probably they wanted to say that FIR would be registered only after that information is signed by the informant within 3 days. That discretion that has been given to the police officer in those cases where the offence is punishable with 3+ years of imprisonment, but up to 7 years of imprisonment, that also is problematic, and I'll be giving you one example. We all know that Lalita Kumari's mandate has been diluted as far as this particular provision in BNSS is concerned. If you see section 106 of Bharatiya Nyaya Sanhita, section 106 of Bharatiya Nyaya Sanhita corresponds to section 304 capital A of IPC. Now, in Lalita Kumari, the Constitution bench of the Supreme Court had carved certain exceptions where the police may conduct what we call the preliminary inquiry. Now, medical negligence cases were such where the police would be conducting PE before registering an FIR. There were other categories and other offences as well in Lalita Kumari case listed, where the police may indulge in, the police may conduct PE, medical negligence being one. When you read the punishment provision as far as section 106 clause 1 is concerned, now there are two clauses. One that would not be implemented from July 1, 2024. We all know that a false narrative was built by certain vested interests that hit and run cases would be creating a lot of havoc, this and that. So 106(2) is not going to be implemented, but 106 clause 2 would not be there on the statute book from July 1, 2024. 106(1) would be implemented. Now for medical negligence, the punishment is still 2 years. If a doctor is found to be negligent in performing some operation that leads to death of his patient, the punishment would be 2 years. Other cases of negligence that lead to loss of a human life would be punishable with 5 years imprisonment. 5 years imprisonment. So this discretion that has been vested in the police officer would be applicable in ordinary cases of negligence leading to, ordinary in the sense that case of negligence in which a non-medical professional is involved, leading to 5 years imprisonment. The police officer would be using his discretion, but when it comes to medical negligence cases, certainly there is no discretion left in the police officer. Now that is a little anomaly that I could think of. The other provision which I find disturbing, if I may use that term, is the provision contained in section 356 of Bharatiya Nagarik Suraksha Sanhita that provides for trial in absentia. Now we understand, we know that a fair trial is a facet of human rights. A fair trial is implicit in right to life and personal liberty flowing from Article 21 and other fundamental rights provisions of partly of the Constitution. Now, when an accused is tried in absentia, what is denied is that fair trial. And there are cases, there are decisions delivered by the Supreme Court where the Supreme Court has categorically held that it's not a mere fair trial, rather it's the quality of fair trial, where the quality of legal aid would also be very, very crucial, that every accused, even if he has been accused of the most heinous and the most serious offences, is entitled to. Now, while lawyers represent their clients, they seek instructions what line of defense they have to pursue. That all depends on the communication, regular communication and instructions that they receive from their clients. Now that would be lacking, that would be that would be absent in such cases. Therefore, this provision 356, if challenged in the Supreme Court, I believe that would be found to be unconstitutional. I understand that I started the time when this whole session was to be wrapped up. So these were a few issues that I thought that I must flag and must present in front of the legal fraternity to ponder over. Thank you very much once again for this wonderful opportunity. Thank you.